Hey, Juanita. Hi, everybody. How are you today?
Hi Mark, how you going? Where are you coming from today?
Well, today, where's Westy today? Westy is, I am in the Gun Send Motel at Gundawindi. I actually saw New South Wales. In fact, I went over New South Wales. I was flying into Gundawindi. Today, I actually had to cross over into enemy territory.
Right,
I
right.
don't know if I should tell anyone. I might have to do 2 weeks, you know, two
Quarantine.
weeks, what do you call it? Sitting by myself in a room or something. But anyway,
Much
no, it's
like
just
you
been
are now.
just like I am now. No, I did a 2 hour presentation to a succession planning workshop for at Gundawindi today. So that was very good.
Fantastic.
So I've been talking for 2 hours. So it must be it must be your turn.
So
But
hello to all your new friends at Gundawindi.
that's right. That's right. I told them about the show. Um, yeah, today I thought we'd touch on because it was relevant to someone I was talking to last week, and we were having a great conversation. They got 4 kids, and they really need our help in regard to creating their succession plan around, creating asset protection and all those sorts of things. And I was having a great conversation with mum and dad. Two of the kids were there, and they were on board with the need to get succession planning sorted. And then he said, the dad asked me, he said, "So Mark, what's this going to cost me?" Now, bear in mind, they've got an estate worth $15-20 million. And he said, "What's this going to cost me?" And I said, "Look, on average, an estate that sort of size, between my fee, solicitors' fees, and so on, it's probably going to cost you maximum $25,000 to get that solved. You've got 4 kids, you've got an estate worth $15-20 million. It's going to protect those assets and blah, blah, blah." And it was like a switch just went off. It was like, seriously, I'm not going to spend $20,000 on all that stuff. And the conversation basically just stopped and went on to something else. And I thought, wow, most people understand the value in what we do, how we create family harmony, protect the assets, and so on. And so I thought today we'd talk about, if it's sort of, $15, $20, $25,000 to, depending on how complicated all the stuff is, to protect their estate, and they don't do it because they're worried about the cost. So my question, Juanita, is, and you've had experience in this stuff, what are the costs on the other side when the proverbial hits the fan and the kids start fighting after mum and dad have gone, and it just turns into a real dust-up? What's so they've saved $20,000 today, but how much is it going to cost them in X years' time?
Could be double that to 10 times that to even more. So I think the word that you mentioned that really struck with me is the value. And so you need to be able to see the value in the investment you're making, which is something that I know you and I work hard to explain to our clients. And we're going to go through a few examples of things that can go wrong and why that initial investment can actually save you money in the long term.
Well, look, absolutely. I mean, my understanding, when you look in the papers at, I posted something a few weeks ago in regard to a rural family in Queensland where 2 brothers were fighting over mum's estate, and she hadn't even died yet. And the legal fees in the stoush before mum has even died, was into the hundreds and hundreds and hundreds of thousands of dollars. And I mean, that's kind of where it goes. I wouldn't think you're ever going to get any change out of $100,000 if a fight starts. So,
No.
any thoughts?
Yeah, well, if a matter if an estate dispute goes to court, whether it be, and I should even say, even if it doesn't. So if a dispute is commenced and a settlement is negotiated or mediated, it might not go to court, or it may go to court. But along that process, any sort of estate dispute that's commenced can end up costing, on a good day, $30,000 to $50,000 for the estate to solve. On a bad day, 10 times that, so hundreds of thousands of dollars to solve.
Yeah.
So huge amounts of money, and it's not correct to say that the expenses of an estate dispute always come out of the estate. That's not necessarily so. If someone acts in a manner which was inappropriate, they may be responsible for their own costs, for example. However, usually the executor's costs always will come out of the estate unless they breach their own duties. So you can expect, as soon as a dispute about an estate is commenced, then whether it gets settled or whether it eventually goes to court, we're talking of tens of hundreds of thousands of dollars. So by doing some forward planning that can minimise that happening, it certainly will no doubt save that exact amount. That's a very clear difference.
Yeah, that's forgetting all the other value, regardless of whether they fight or contest the wills or do anything. I mean, there's a whole lot of other value in regard to what we do to help people get all this stuff sorted in regard to the succession planning and creating certainty for the kids, creating family harmony, and having the kids being able to understand what their options are for the future, and all those sorts of things that don't even relate to contested wills and so on. So I just found it very, very odd. It's been a long time since someone sort of questioned the value of what it was that we do, and just got me thinking about how I best explain the value as a package and compare it to what it's going to cost at the other end. But you sent some issues today, Juanita, in regard to other things that can go wrong, because the due diligence that you guys do as part of my process with clients. I mean, the due diligence where you look at all the structures, the ownerships, down to insurance, superannuation, control of trusts, and all that sort of stuff. I mean, that in itself can save so much grief, heartache, apart from money, so much grief and heartache as well, can't it?
Yeah, that's right. So I've got some specific examples that I'm dealing with right at the moment, which I thought would be useful to discuss, because if you see these sort of situations, in real life examples, you can really start to appreciate what can go pear-shaped, I think, and then hopefully see the value in getting it correct from the start. So the first
I like
thing
pear-shaped. Pear-shaped is a good word.
Pear-shaped, yeah, very legal word.
I came up with a new word today as I was talking at this 2-hour presentation. And
can we say it?
Can we say we can say it? It was ickiness.
Oh.
Ickiness.
Yeah,
so
I like it.
I'm going to trademark that. Stop the family ickiness.
Yeah, I like it. It's very apt. A matter I've got now, for example, a deceased fellow did a will and had the very best of intentions to look after his children and surviving wife. And in that will, he left 3 particular properties to 3 of his children, or his 3 children. And so a different property to each different child on purpose. And then everything else was to go to his surviving wife and the superannuation, which is dealt with separately, and we'll talk about it in a minute. The problem was this: after he passed away, one of those properties, we found out the manner in which it was owned meant that he owned it jointly with his wife as joint tenants, and therefore that property did not form part of the estate. It was an automatic, by survivorship, it went to his wife and wasn't an estate asset. So different to the other properties which he owned as tenants in common, which means he could gift his part of the property. And so the result of that was property A went to child A, property B went to child B, but poor child C didn't get anything at all.
Wow.
And the mother got her gift. So unfortunately that's turned into a bit of a family dispute, because although it began with the best of intentions to rectify the situation that had happened, over that period of time the negotiations broke down and left child C in a unfortunate situation where she needed to take some action to try and preserve her rights. So all of that could have been solved, and in fact it was intended to be solved by changing the ownership of the property to the correct way, which is an exercise which can maybe cost a few $100s. It doesn't cost very much at all. that those wheels were put in motion actually, but unfortunately they weren't completed by the time the gentleman had died, which is another sad part of the story, that the delay in taking action has had this effect. So you can see just by that simple little question about that change, that ownership of that property, has meant that one child, C, has missed out on a property worth hundreds of thousands of dollars that her father wanted her to get, and everyone knows that, and has also ultimately cost her and the estate legal fees, which certainly Dad never would have had the intention of being so. So it's a real icky story. You can see
there's a high ickiness factor in that.
Yeah, it is.
Anita, I think.
Yeah. And, from a non-tangible aspect, unfortunately the relationship between the siblings, in the family in some parts has deteriorated, which is a real shame.
Yeah, that's unfortunate when that happens. And I mean, the ultimate aim of all this, we keep saying over and over again, is that kids always get together at Christmas and they're still mates. And anything you can do to protect the relationship between the children is paramount.
Yeah. Oh, absolutely. Yeah. And you that's obviously the wishes of that deceased person. I have another similar example dealing with superannuation and life insurance, and I briefly alluded to that earlier. As many of our viewers would know, and as we've discussed before, superannuation and life insurance is treated separately from the will, usually. And so most people are very surprised when they realise or are told they can't just leave their super in the will without taking some extra steps. So a matter that I'm dealing with at the moment, the deceased got his form for his superannuation to nominate who he wanted to receive his superannuation, so got that part right. But in that, nominated his elderly mother, who he was very close to. Unfortunately, you are not allowed to nominate a parent as a recipient of your superannuation. So the superannuation laws say that you can only nominate a child, a spouse, or a dependent, or your legal personal representative, that is your estate. So unfortunately, what he intended to achieve by looking after his mother, by putting her on that form, didn't work out, because the mother was simply ineligible, and then the trustee has the discretion as to who the superannuation can go to. Now, that becomes an issue when you've got potentially dueling beneficiaries. So, that instead of that money being directed specifically to mum, who he wanted to, it now becomes embroiled in an estate dispute, and is that purely at the trustee's discretion as to who it goes to. So, really unfortunate, because that wasn't his intention, and poor mum, who he really wanted to look after, hasn't been looked after in the way that he had hoped.
So who's ending up with the money in that case?
Well, stay tuned. We haven't got to the end of that yet.
We haven't got to that one yet.
Yeah, that's right. But again, that's caused delay in it finalising the estate. It's caused expenses to everyone involved, and obviously a lot of stress too, and unpleasantness.
Sure.
So, with some simple advice as to the appropriate way to funnel those funds that he wanted to look after mum, that could potentially have received, ended up in a different result in the way that he wanted.
Sure.
And I mean, if you think about what's in your super, so people have hundreds of thousands of dollars in their super. So just by filling out that form incorrectly has made a difference of $300,000 to $500,000 difference for that gentleman.
Wow. Yeah.
And his mum.
And his mum, and the person he wanted the money to go to. But anyway, there's probably something there in regard to the lack of advice that he was given as part of his superannuation fund too.
Yeah, that's absolutely right. So obviously at the time, didn't unfortunately obtain that correct advice, and as a result, that's what's happened.
Yes, that's a whole different issue in regard to advice in superannuation funds, because now, the advice people get in superannuation funds is so limited because of fee restrictions, and so that's a whole other issue. So, okay, you've got a third example about a do-it-yourself will kit, the old perfect, the will at the news agency trick.
Yes. Now, my philosophy is a will is better than no will, usually. But a will kit usually can go wrong. Well, in this case, it did go wrong. So a lot of people will say, well, why can't I just go to the news agency and get a DIY will kit and fill out myself? There's a few reasons why. The first being that it doesn't deal with those issues that I've just spoken about. So it doesn't give you advice on jointly owned assets. It doesn't give you advice on how to deal with super. So that's just the starting point. A will kit won't give you that advice that you'll get from an advisor that knows what they're doing. My experience with will kits is that people just can't help themselves, and they like to add their own wording. And it's a funny little thing, wording in wills. You know, often you read them, and even though nowadays there's a tendency to use more plain English, there is specific reasons why some phrases and words are used, and they can turn on the result. The result can turn on those wordings. So in an example I had a few years ago, a gentleman bought a will kit and filled it in, filled in the spaces, did quite well there, but just kind of felt that it wasn't really explaining what he wanted to, and then proceeded to write over the page and onto the next page his own personal explanation of what he was trying to do above. Unfortunately, that just made the whole thing ambiguous and didn't provide clarity at all. And what happens is when a will is ambiguous and we don't know exactly what was intended or what it means, an application to the court has to be made so a judge can basically interpret that will for us. That is potentially 30,000, 50,000, 100,000, depending on the dispute. Yeah, so a $30 will kit in this particular circumstance turned into a $30,000 court application. So, you know, for the sake of getting that initial advice, and just for a basic will, you know, we don't need to do anything tricky or any testamentary trust for that particular gentleman, but if he had got some advice and done a basic will, then that wouldn't have happened. And in those sort of applications where that person was the unintentionally the cause of the application by his creative writing, the costs do come out of the estate there. So his estate ended up being $30,000 less because of those extra words that he handwrote on his will kit. So, I mean, that's a very common, it is a very common occurrence. So we see a lot of that going through the courts.
Okay, so interesting, isn't it? People are trying to save money and it ends up costing them a fortune.
Yes, absolutely.
Another example.
And then I also mentioned, Mark, on my little notes to you this morning, because I thought
you did very well writing all those notes. Thank you.
Oh, such a fun topic. There's so much. Well, not fun for the people that get it wrong, but so interesting.
It made me think I didn't need to do any preparation today. That was very nice of you. Thank you.
Well, I think I think these examples hopefully are starting to show that that when we say it's a good idea to get advice from a professional and get it done properly, it's not because we're acting in our own self-interest to get our own fees. These are real life examples that I have experienced in the last few years, and you can see the dollar value. It's just the way it is. So another example that came to mind is having no will. So what some people might say is, I don't have much, why do I need a will? And we've spoken about that before, but to give you an example of what can be, what the difference can be monetarily, I'll tell you this story. So if you die without a will, what happens? Well, your estate is left by a formula that the law prescribes. And as we've said before, that may not be what you want. It may be. But to give you an example, if you have a spouse and 2 children and you die without a will, the law says your estate is split up as follows. So the first $150,000 to your spouse, a third of the balance of your estate to your spouse, and the other 2/3 of the balance is split between your kids. So that's okay so far, I guess. So most people wouldn't be too concerned if their kids are getting looked after. But the issue sometimes happens is when the most of the estate is in a house. So if you don't have much money in the bank, but the bulk of your estate is in your property, now what happens is your property that your wife and children live in has to be split up potentially between your wife or your husband and the kids.
Yep.
So all of a sudden, spouse is having to share ownership of the house with potentially minor children. And you can just start to think that that is a logistical nightmare, isn't it?
We're having a party, Mum. No, you can't. Yes, we
Yeah.
can. We own it.
Yep. Or when they turn into adults and move out of home and now they own a share in that house, that can restrict what, mum or dad can do with that house. So, in dollar terms, if you're thinking about, a third or a half of a house, here we're talking hundreds of thousands of dollars that decision of not having a will can make, can affect.
Interesting. They're all just little mistakes at the time, aren't they? Which just end up being very, very, very expensive.
Yeah.
But all because they haven't taken advice.
Yeah. And, they might not even be mistakes. They're just, you don't know what you don't know, I suppose. And so by not getting the right advice and doing things properly, these are the unintended effects of doing that, So, yeah, it's most unfortunate. We've spoken a lot about testamentary trusts before, and we're not going to go into them today, but if you do want to hear about them, go back to our previous shows and find out all about them. But
right.
Again, another very tangible effect that estate planning can make, good estate planning can make, is if you leave your estate to your beneficiaries, for example, your children or your spouse, directly in a basic will, it then just goes into their name and they are responsible for that. And the option also is to put those assets into a testamentary trust, which protects them for the beneficiaries. So to give you some dollar examples, if you had a couple $100,000 in the bank and you give it all to child A, they run a business and then they get into some insolvency problems, go into bankruptcy, all those assets in their estate. So that $100,000 goes to the trustee in bankruptcy, gone.
Yep.
Whereas if you put it in a testamentary trust, there is an element of there is protection there, and it does not go to the trustee in bankruptcy. So that simple structure can save $100,000 plus there. Whatever that dollar amount is for you.
Sure.
Similarly, if that same child that received you let's say $500,000, later on experiences a relationship breakdown and goes through a divorce and a property settlement, then that $500,000 is now exposed to that property settlement. And they could, how long's a piece of string? They could lose half more of that money. So that turns into $250,000, $300,000 gone. Whereas if you had placed it in the right structure in a testamentary trust with appropriate control mechanisms, that there would have been protected and may be taken into consideration, but certainly would have been lost to that child and to your family. So again, you can see how just that little bit of advice can save hundreds of thousands of dollars.
Absolutely. Do you have another example as well, or because I was going to talk about? Sorry.
Yeah, well, another example, continuing on in that theme, is you might have a child or a beneficiary that just isn't good with money. So, it might not be that something bad happens to them. It may be that they are not good at managing their money. It could be that they have a gambling problem or a drug problem, or that, any of those sort of personal issues. And so, again, that can just be blown up against the wall if those funds are lost, rather than being put in an appropriate structure. So this all comes back to getting the right advice to protect what you leave for the people that you want to.
I'd just like to touch on what happened today, and that is Michael Cowley is a solicitor friend of Tom's, part of the Australasian Law Group and so on, that Michael practices out here in Goondiwindi. And he was talking about the use of testamentary trusts and structuring and how to properly set up your assets and so on when you purchase them, because many people purchase things in either their own names, joint names, in a company and so on, which, when it comes to succession planning, just makes it more difficult to transition the assets across in a protected way with succession planning. And So a couple of people came up to me at lunchtime, Juanita, and said, we're sitting there listening to this lawyer give this presentation in regard to structuring, and as we were talking about with those clients the other day, you and I, so we've been given this advice by our accountants on we should just set it up in our own names or joint names and all that sort of stuff, and they said, yet we sit here today and we hear you talking about how to protect your assets when you purchase things, and they said, we all have good accountants and other professional advisors, and none of our professional advisors have given us any of the advice that we have received today. And had we received that advice back when we were purchasing multi-million-dollar properties and so on, it would have made a huge difference to the outcome when we get to transitioning those assets onto our children as part of our succession plan. And so they asked me the question, which I just can't answer, and that is like, so why do we get given advice which isn't the most appropriate? And this is a question which is as long as a piece of string, and so it's not just getting advice, is it? It's the trust in knowing that the people that you go to for advice are people that actually know what they're talking about. So how does Joe, the punter in the street, how do you distinguish between what's good advice, thoughtful advice, and it's like wills that are done for 99.99% of all the people I've ever met in my life. The wills are atrocious. How does the average guy in the street know who's a good lawyer, who's a good accountant, what's good advice, what's bad advice?
Yeah, a couple of things come to mind that if you're a client getting advice is certainly don't be afraid to ask questions. And if your questions aren't answered, there's an alarm bell ringing. But a couple of things. I know that we like to provide, for example, our clients with options. So, the main thing is for us is that you understand what your options are and your risks are and what, we recommend the best choice for you is, but then you decide, like it's in your power. So, as long as you make an informed decision, then that is the most important thing. If you're being pushed into one particular product or price or answer, well, maybe answer is not the right word because often there is an answer, but if you're feel you're being pushed into a certain direction, then don't be afraid to ask the question because there are different options available to you. And without being too vague, if we're giving advice to a client about their estate planning, we have different packages. So, this might suit you. It costs this, and this is what it does. There's another step up. This gives you a bit more protection, and it costs this. But you might not be in a position where you feel that's suitable to you now. So, don't be afraid to ask questions. Make sure you're not pushed into a corner. You're given some options, and probably have a think about whether the advisor is speaking to you with your goal in mind, because it should be all about what you want to achieve in the end, not what your advisor wants to achieve. So every client is different. So it's not going to be the same answer for every client. So that's important too, that you feel that your goal, your end goal is being what's discussed, not the solicitor or the accountant's end goal.
Look, absolutely. Yeah, look, absolutely. And the other issue is the clients don't know the questions to ask, and that's the issue. They don't know what their options are because they're trusting in the advice. Someone's come up and said, this is the way you should structure it. And you just go, well, yeah, okay. People should be asking and saying, well, can you give me two alternatives and make that part of their normal routine when they're talking with their professional advisors is ask the advisor for other alternatives apart from, what the advisor gives them. So, I like your idea of the three packages. You have different packages provide different levels of protection in testamentary trusts, and at least the client then has a choice. But it was just an interesting question to me, and I thought, wow, isn't it sad that most people aren't getting good advice because they don't know who to go to and they don't know what questions to ask. And
I don't think I certainly don't think a client's expected to know the legal questions to ask. That's the responsibility of us to draw them out. But certainly we always ask our clients straight up, right at the front, is there anything that's bothering you? Like what do you want to make sure that I address for you today? What's causing you to lose sleep at night? What's bothering you?
absolutely.
And if I haven't covered them by the end, let's make sure I do. So that's really important.
Yep. Okay. Time's up as usual. Been fantastic. Thank you, Anita. Full of wisdom and good advice. So thanks for your time today, and look forward to catching up next week. See you guys.
Bye.